Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everyone? Hello, Angela. Good morning, kitties. Good morning, Deb. Good morning, Angela. Tammie. Tricks for Kids says fingers crossed unless he has laryngitis. Let's hope. So, pretty amazing filing by the Commonwealth. The state or the defense wants to still bring in the ARCA experts and not bring in their bias as unbiased witnesses. And the Commonwealth wrote a excellent reply to it, where they basically brought up the federal investigation and said we know that it was started by the defense. And we don't know the full details of it. It's yet not known to the public as to why or what they were exactly told to investigate. But we know that ARCA was part of it. And they only took information from the defense. So, pretty incredible. Elizabeth Proctor did an interview that I didn't think was particularly helpful to her case. I understand why she did it, but they also want to increase the buffer zone. I just don't. I understand, when you're the victim of a smear campaign, can feel awful and you want to speak out. It just, I don't know. Certain people are reporting that Michael Proctor has lost his job. And it hasn't been released yet. I haven't heard anything one way or the other. I don't know what people know. They're also trying to the Commonwealth is asking to increase the buffer zone. 200 feet is ridiculous. From the courthouse. That was, if you were watching, thanks to everyone who showed up at Kick last night. We're just playing the first 2 episodes of the Karen Reed, A Body in the Snow. Terry Moore, the producer, creator of the TV show, disgustingly titled A Body in the Snow, about John O'Keefe's murder. Says it's a big mystery. We can't figure it out. It's a big mystery as to what happened to John O'Keefe. I don't agree. And I think her producer, Caitlin Cutt's favorite 2 documentaries are Paradise Lost the Innocence Fraud documentary about the West Memphis Three, in the staircase, the Innocence Fraud documentary about Michael Peterson, which embedded itself with the defense. The same thing that Karen Reed they did in Karen Reed's case. They embedded themselves in the defense, and they're showing the case entirely through Karen Reed's eyes. She's the main heroine of the piece. So already it's skewed. You cannot tell both sides and embed yourself in the defense. First 2 episodes were, I thought, not very helpful to Karen Reed. I'll probably be talking about it tonight. Not going to be doing much talking. Again, so here is, let me just read some of this stuff about the Commonwealth. Now comes the Commonwealth in the above captioned matter and respectfully, opposes the defendant's motion in limine to allow evidence of lack of bias. The balls on the defense. Their scheme. Of course, we know the ARCA experts in an explosive hearing about a month ago. That's my memory of it, a month ago. Do I have the timing right? It was exposed that they were paid $23,925. They were retained by the defense, and that their testimony that was presented to the jury is unbiased, completely independent testimony was structured, crafted by the defense. So I don't know. They have more expert witnesses that the defense is bringing in, ex-FBI people. That's often a grift and innocence fraud we see. People like Jim Clemente. Steve Moore. They're all ex-FBI. Why they're ex-FBI, you never know. But they throw their credentials around, and they throw shade on and suspicion on investigations with outcomes that they want to disparage. Jim Clemente worked for on Jerry Sandusky's case. Basically giving a okay to the head of the football program there. And I think it used to still be up online. You could read Jim Clemente's report about that. They also shilled and told complete untruths, i.e. lies about Amanda Knox. Went on programs, said they were not paid, completely independent. They presented themselves as. So we have some ex-FBI people coming in, or one at least for the defense they want to bring in. Yeah, he basically absolved Joe Paterno of any knowledge. Jim Clemente did, when the New York Times broke a story that said that Paterno said that basically Jim Clemente investigated for the Paterno family. I believe the Paterno family hired him. And lo and behold, did Jim Clemente come out with the conclusion that Jerry Sandusky was such a crafty predator that no one could have known. He was a nice guy predator that hid in plain sight. When the New York Times broke the story that Paterno knew as early as 1976, he got complaints about Sandusky. So they're hired, they're money grifters. A lot of these ex-FBI people, they go where the money is. They're happy to absolve disturbed, deranged, dangerous people. Okay, back to the Commonwealth's opposition to defendants' motion in limine to allow evidence of lack of bias. I mean, I just have to laugh. Contrary to the defense's repeated representations to the court, the public, and the first jury, the employees of ARCA LLC. Let me just make sure that this hearing hasn't started. No. Okay. It's still just going to refresh. We don't even have a fan yet. The employees of ARCA LLC were not impartial nor unbiased. The Commonwealth has a good faith belief that the defense instigated the now closed federal investigation and actively participated in providing selective information and materials to the United States Attorney's Office to attempt to propel and shape the federal investigation. First, the extent of the murky relationship between the defense team and the past administration of the United States Attorney's Office is still unknown. To this day, it's unclear how that relationship may have shaped or impacted ARCA's efforts. The actual directive to ARCA made by the past administration of the United States Attorney's Office and any shaping of ARCA's efforts are not known. And there's a little footnote here. Numerous TUI requests have not produced sufficient relevant and material information needed to identify the extent of the relationship between the defense and the U.S. Attorney's Office and what, if any, impact the relationship and source of materials may have had upon the scope of ARCA's directive. Directive and efforts, they write. Second, there is no adequate assurance that the ARCA witnesses lack bias. The past opportunity to voir dire the ARCA witnesses did not mitigate the lack of transparency about the ARCA defense relationship. The defense did not inform the Commonwealth about its substantive relationship with ARCA until February 13th, 2025. Notably, the defense disclosures came one day after the new administration at the U.S. Attorney's Office produced, in response to the Commonwealth's TUI request, materials that included correspondence between it and the defense. So that's curious because, Hank Brennan initially thought he got this from the United States Attorney's Office, and he had to correct himself that these materials, emails between ARCA and the defense saying, your voir dire was great. If you don't want me to say this, I won't. We have to make the jury see that it didn't matter that I didn't look at the car or didn't look at any of the real evidence against Karen Reed, including her car data. But never mind that. Hank Brennan thought he got that from the U.S. Attorney's Office. And he had to correct himself. He got it from the defense. But here in this filing, he says he's making a connection between the change in staff at the United States District Attorney's Office. One day after he got all these things came one day after there was a change of guard at the new administration, he writes. Or this may be Laura McLaughlin. McLaughlin wrote this. And Hank Brennan signed it. Not sure who wrote this for the Commonwealth, or it could be Adam Lally, could be, or all three of them together. Notably, the defense disclosures came one day after the new administration. Now, read it again. Notably, the defense disclosures came one day after the new administration at the United States Attorney's Office produced, in response to the Commonwealth's TUI request, materials that included correspondence between it and the defense. Before February 13, 2025, the Commonwealth was wholly unaware of the defense's relationship with ARCA, including proposed retainer agreements, intention to compensate, and NI collaboration relative to questions and answers at trial. Rather, the questions posited by the defense during voir dire testimony and trial testimony created impressions that were clearly not consistent with the actual representation between the parties. The voir dire was necessarily insufficient and fruitless. Third, the ARCA witnesses have a clear bias in the case. So this is a lessee's argument. The voir dire was the notice. That was the discovery. It wasn't that we had to do voir dire because the judge had to make up for the fact that the defense hid discovery from the Commonwealth. And that's just their way to continue to hide discovery from the Commonwealth, but never mind. Third, the ARCA witness have a clear bias in this case. In addition to the shifty trial testimony relative to the witnesses' relationship with the defense, the ARCA witnesses did not contain their opinions to the parameters of the reports during trial testimony. At trial, Dr. Wolf and Dr. Rentschler, let me just check. Oh, we got a hearing. Karen Reed's in the courtroom. Let me share my screen.
Is this the red one?
Oh, you know what?
Oh, you have an extra one?
Yep, I don't have an extra one, but I'm not going to need it.
Karen?
Such an odd relationship between Karen Reed and her father.
Nope, it has to be up. Till we get going, then you can put it on.
Oh. So we've got a fan. Let me continue. Let me just read a little bit more of this. What an odd relationship between Karen Reed and her father. Third, the ARCA witness have a clear bias in this case, in addition to the shifty, what a word, shifty, murky, shifty, trial testimony. So he uses a murky relationship between the U.S. Attorney's Office and the defense. Now the Commonwealth refers to the ARCA witnesses' testimony as shifty. In addition to the shifty trial testimony relative to the witnesses' relationship with the defense, the ARCA witnesses did not contain their opinions to the parameters of their report during their trial testimonies. At trial, Dr. Wolf and Dr. Rentschler, posing as neutral, independent experts, were permitted to speculate and render opinions far beyond what was stated in their written reports. Oh, what a surprise. What a surprise. The Commonwealth has good faith belief that the defense instigated the now closed federal investigation into John O'Keefe's death and actively participated. In providing selective information and materials to the United States Attorney's Office to attempt to propel and shape the federal investigation. To this day, the correspondence between the defense and ARCA witnesses is missing context. No discovery has been forthcoming since February 13, 2025. Notably, during the pendency of this case, this is the only time the defense produced reciprocal discovery prior to a discovery deadline. See, that's their technique, is that they constantly violate discovery. Further, Brennan has uncovered more potential Rule 14 violations by Reed and ARCA. Notably, photographs have recently been discovered by the Commonwealth and subsequently produced in discovery to the defense depicting Dr. Rentschler attending a private luncheon and conversing with the defendant's father at the luncheon. If Reed's team is allowed to mention the probe, notes Brennan, then I'm reading from Grant Smith Ellis's coverage, then the introduction of the investigation to the jury is only balanced if the jury is fully informed about the actual relationship between the defense and the prior administration at the United States Attorney's Office, any impact the defense's contributions. Oh, here we go.
Is a decision on the Commonwealth's motion to exclude employees of ARCA. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCA witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
Wow, a bombshell. Bombshell first off. Glad I turned on the sound. So this is a sealed sidebar. We're back at the fan again. I'm going to keep up the sound. So excuse the hissing. I have my air purifier on, my fan on. Excuse all the noise. I hope you can stick with it, deal with it. But what she's going to do about it is going to be the most interesting thing. It's a flagrant violation. She found out that this is a willful violation, a willful lying to the court. She didn't call it that, but that's what it is. Happy birthday, Murder by Maestro. I don't know if he's in the chat, but I did want to thank you, D. Walker. Appreciate it. Thank you for supporting, being such a super supporter of this show and allowing me to do these live streams. This is all listener supported, as you know. So let's see what she's going to do about it. My kitties are sleeping right now. My one kitty kept me up all night crying. Thought it was playtime. Poor Miss Little. Do you really feel that way? I don't feel poor any defense. Written by Miss Little. I mean, they said we can't hand over discovery. We don't have it. When they retained and paid, I mean, come on. I've never seen something like this be exposed in a trial before. Have you guys? I go by Steffo. Says this was so inappropriate by the defense to do. Can you imagine if Karen was not found guilty and no one ever found this out? Right. There's no appeal for the Commonwealth. She gets acquitted and that's it. So I'm going to be listening along with you guys today. I'm not going to be saying much. Oh, they're back.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor. May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, this cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his finding, he says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information, but it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his 1-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, He has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin, and in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right, thank you. Mr. Brennan?
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. His book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries, intracranial pressure, number 2 under journal articles, initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the Clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations, specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth, but we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Miller, say anything final?
Yes, thank you, Ron. Mr. Chairman. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Dalbert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf. And it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
At some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon engaging in the operations and the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like
we attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did she adopt it? Was there? Okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
It would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
And so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time, right?
This is more attended to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
do you have the day of her testimony?
Oh gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind,
Sure.
Ms. Hanley testifies, then that would be the appropriate time.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great. Thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba witnesses. Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited, this argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the quals, bans the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So Mr. Brennan, you can have a seat again and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All right, so that was 5:59. The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view,
Okay.
okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
Mhm.
If
How do you propose that's done?
if it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions. And I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place, if that's what we decide. We may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars. All right, so defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. Yeah. 562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know.
Okay.
He or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously is not something it should be in a motion. Okay. If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right. So you all need to talk. All right. And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable. It seems as though the presentation has a deliberate point to promote a cause, but it doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
But I'll take a closer look at both of these and have something later. All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay,
I believe the Commonwealth has indicated that they will agree to that.
okay. All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank you.
Okay, so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, well, we covered all of that last as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to panel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that, I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with, and jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it, and if you can't, I need that. I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can backbone to start with.
So let's do that. What Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides. $570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that it did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, you know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it. In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, and which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others, consider an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers. So
my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to this Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at their family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. But we could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense.
Your Honor, I am. And to
Okay.
answer your question, the defense preference would be for the Commonwealth to go first. And
All
we
right.
would respond, including with regard to my motion.
Okay, so Mr. Brennan, our paper 386, your number 12.
Your Honor, our paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth vs. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right, now I'll hear you, Mr. Lassie.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy-dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states 2 paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
Can I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
All right, to the court, please.
You are muted.
We'll be recessed 15 minutes.
Okay, we're on a break. Just very strong statements. I had to go back and re-listen because I was confused, and I still am confused as to how Hank Brennan's going to bring in Aidan Carney if the judge allows it as to show consciousness of guilt, but they're not allowed to ask. But they don't want to ask witnesses questions about their harassment. I guess two can coexist at the same time, maybe? Seems like that would open the door already for both sides, but okay. Very strong language from Hank Brennan this morning. He's bringing in the documentary. He's bringing in Aidan Carney's pat on the butt, something that's up on my channel. Hold on. Let me see if I can pull it up so everyone can see what he's talking about. It's up actually on two ways that you can watch it. It's a short Where is it? It's in my video section. But I'm going to show you the video, which is just no music, no licensed music. Here, let me just. So watch David Yannetti. They're on their way to court. Here's Alan Jackson. David Yannetti's behind. Here's Karen Reed. Watch David Yannetti. And Turtle Boy is going to be on the left here, left side of the screen. Look, this comes courtesy of Grant Smith Ellis took this footage. So right there, you see his hand on. So keep your eye on the hand. That can show you where to watch. So good job. So they were publicly distancing themselves from him. And there are tons of phone calls between, I think there's like 29 between him and Alan Jackson. Don't quote me on that figure. At least, they said in the affidavit to search Karen Reed's 2 phones that she had for communications between her and Aidan Carney. There you go. Also, he said, you've heard, wait, am I sharing my screen? Did I share my screen? Hold on, let me do it again. Did you guys see that? Okay, hold on. You want to see, wasn't it Microdots who fell over the fence? Sure. Hold on one second. I thought it was Microdots who fell over the fence and not Tom's CPU. Am I wrong? Hold on one second. Let me pull it up. Okay, hold on. Okay, hold on. Okay, here we go. This is also from Grant Smith Ellis. So this is, anyway, here's the guy behind the Microdots account, Richie Keogh, trying to jump over a railing and falling on his face. And the thing to watch is all the, just the reaction between, like, no one on the Free Karen Reed team says, "Are you okay?" Stops. Nothing.
Oh, she took a different way. Oh my dear God, he fell. Richie, are you okay? Gonna take the plea, Karen?
Karen Reed will never. I did a tweet. You can follow me on X at Roberta Class Pod. If you're not already following me, saying that Karen Reed, this is Grant Smith Ellis's mother, was saying, oh, she'll take a plea as soon as Turtle Boy comes into this case. I don't know if he's ever coming into this case with this judge. Let me just check the hearing, make sure nothing's going on. Still on a break. But I don't think she'll ever take a plea. I said she'll be blaming other people for her murder of John O'Keefe till the day she dies.
Oh, she took a different way. Oh my dear God, he fell. Richie, are you okay?
I mean, she'll never plead to the smallest of charges in this case. That's how I see it. But just very shocking from Hank Brennan saying, essentially that you've heard the tapes between Gretchen Voss. And I don't think the judge cited one instance where Alan Jackson said, I'm not supposed to tell you this information, but here it is. And wait to report on it until we put it in a filing. So directing the press. And so it would be foolish to not think that they did the same to Turtle Boy, gave him early information and waited till they put it in a filing till he could put it out, or to put it out in some other opaque way that didn't come back to them before a filing. They were absolutely directing the press. And I hate to call Turtle Boy the press. I mean, he's like a blogger, but he gained a lot of influence in this case. So here he is getting admonished in the beginning of the hearing for lying to the court and misrepresenting facts to the court, and then he does it again. So then we get very strong language about fraud, and you heard, and disparaging witnesses in their filing. You hear a little bit of it in the public arguing by Jackson, where he says, well, it looked like Jen McCabe just wanted to insert her witness harassment experience into the testimony. Like she knew that if she opened the door, it would come in. So she did it purposefully, which may or may not be true. By the way the judge and Hank Brennan made it sounded like Alan Jackson. I have to go back and review Jen McCabe's testimony and where that exactly came in. But I remember they opened the door. I remember very clearly that they opened the door to it. But here he is misrepresenting himself again to the court. Again, just this morning. Again, we have amnesia from Alan Jackson. Just this morning, he's admonished for lying to the court. And he does it again. Lies to the court. We just have no control over anyone. We could never say to the public, please don't harass the witnesses in this case. Please don't harass the public. Strange they never did that. You think Karen Reed, with all her power, that wouldn't have toned down her fans? You see the way they give her flowers. They treat her like a queen when she walks in the courtroom door. And very fascinating last night. There are good things about this TV show about Karen Reed. I don't agree with the way it's done. I don't believe you can embed yourself in the defense, call yourself impartial. However, I have to say, Karen Reed showed herself to be a vindictive, troubled, psychopathic woman. She says at one point, it's either Jen McCabe or myself. I mean, either Jen McCabe is going down or I'm going down. I have to get the exact quote. It may have been worded a little differently, but she says either she's going down or I'm going down. Jen McCabe's going down or I'm going down. I mean, if Hank Brennan doesn't bring that into court, he's stupid. He doesn't find a way to crowbar that in if this witness harassment comes in, because that's the essence of it. Did this stop? Hold on. That's the essence of the witness harassment. I can't go down for my own actions. I'm going to start blaming everyone else. Start pointing fingers elsewhere. Get a federal investigation going. Blame the cops. Accuse Massachusetts of deep corruption. I do think there is corruption in Massachusetts, but I think it comes from the defense, these defense lawyers, these judges that turn a blind eye. Now, it is on the record. They got a slap on the wrist, but it is on the record that they willfully, purposefully, that was a very important distinction, not by error, not because they were mistaken, like Alessi said, not because it was misconstrued, purposefully lied to the court, lied to the public. But the court is where it's important. That's where you're under oath for perjury. Perjury broke the law. And when lawyers do it, it has a lot more weight. That's the whole weight of their profession behind them and their good name. I don't know how great Alan Jackson's name already is. Got Kevin Spacey off the hook with a lot of nonsense, but never mind that. So it's on the record. I don't think Karen Read has anywhere to go. I think this is curtains for her. This is the most hopeful I have been in the case since the beginning. I mean, it's very interesting, curious to look back about 2 weeks before Hank Brennan gave his speech about ARCA and dropped the discovery, the ARCA discovery, where it showed the defense colluding with ARCA, hiring ARCA, colluding with ARCA to present their testimony. I won't say this, I won't say that. We got to get the jury to think that. And hiding these discovery. Very compelling piece of the Commonwealth's recent motion about ARCA is where they talk, where the defense wants to bring in ARCA's non-bias and the federal investigation. The Commonwealth says that we don't know the extent of the federal investigation and that there has been discovery. They have hid discovery on every single witness in this case from us. And if Judge Cannone thinks an admonishment is going to make this behavior stop, I think she's naive. And I don't think she's naive. I think she knows. I don't understand. I think she wants this trial to go on. I don't think she wants the embarrassment of bringing any more attention to the fraud that went on right under her nose, and she let go on. There may be sanctions. I doubt it. Doubtful in Massachusetts. But this is the corruption. So, what do you guys have to say about it? Curious. Yeah, it's good for Karen to talk and talk and talk. I agree, Terry. This is, I don't think she has anywhere to go. Where can she go from here? And I think if you look at the defense, everyone at the defense table knows that this is over except Karen Read. Karen Read is in La La Land. Look at their faces. Where can they go? They have, if ARCA's coming in, fine. I think it's a stupid decision, but fine. You've already lied to the court, but we're going to have these lying witnesses back so they can lie some more. I mean, where's the line, Judge Cannone? She seems to not like to exclude any kind of witness, even if they're like, someone off the street, like Marie Russell, attention-seeking true crime fan who wants to testify for Karen Reed. So where's the line, though? I mean, where's the line? So Ark is coming in, but Hank Brennan is going to kill them and cross. The problem with allowing these witnesses in, and here's the thing with it, is let's look at someone like Elizabeth Loftus. She was destroyed in Cross because by John Lewin, D.A. John Lewin, who I've interviewed many times on this show. He's known as King of the Cold Cases. He tries cold cases and wins many of them. So they're known as some of the hardest cases to try, and wins them in Los Angeles. But he really had done his homework on Elizabeth Loftus, who's a memory expert, and who there's a lot of problems with her. Studies can't be repeated. I would call her, in my opinion, this isn't a fact, my opinion, my view of her is that she's a fraud, and that her studies have been used to get defendants off all over the country, in that eyewitnesses are so unreliable. And it did actually get Tim Hennis from his second trial acquitted. And then DNA came about, and this is for the murder of Katie Eastburn and her 2 daughters. He left one baby daughter, infant, alive. Rape and murder of Katie Eastburn and her 2 daughters. DNA came about, and so here Elizabeth Loftus says these are the 2 worst eyewitnesses she's ever seen. You can't trust them. And she toured around the country with Tim Hennis to all these Innocence Project conventions, to talk shows. She went on the Joan Rivers show with Tim Hennis, said this is an innocent man. There was a TV movie made for TV movie called Innocent Victims, all about Tim Hennis's wrongful conviction. You can still watch it on YouTube. And DNA came about, and it was Tim Hennis's DNA found inside Katie Eastburn, or to a statistical degree, what we would call a match, but, to a scientific degree of certainty, whatever, however they put it, lawyerly. Anyway, so to get back to Elizabeth Loftus, she was destroyed by John Lewin on the stand. I think she's convinced, my point was that she's convinced young people all over the country, her ideas are being taught over and over again, that you can't trust eyewitnesses, you can't trust your own memory, that there's no such thing as recovered memories, which I believe there is. Recovered memories therapy is a little different. Not talking about that, but I do believe people have real recovered memories or repressed memories. And she's basically testified for Ted Bundy. Oh gosh, so many people. Ghislaine Maxwell, I saw her testify for. And that's my point, is that in Ghislaine Maxwell, she dazzled. In the Robert Durst trial, she fell flat on her butt because she was so destroyed by cross-examination, because the prosecution had done their homework so well, so thoroughly. So you worry about that one witness that will convince the one juror, or the whole jury. It didn't move the needle on Ghislaine Maxwell, but would she have been convicted of the charge she was acquitted of? Maybe. I don't know. What was the thing that they, what went on in deliberations? Hard to know. But she's Night Stalker. She's testified for the Night Stalker. I mean, she is the patron saint. She's pen pals with Jerry Sandusky. Bill Cosby, she's testified for. Lots of violent and dangerous people. She will advocate for their innocence. She's a favorite expert of the Innocence Project. And there's no story, too absurd for her to say possible innocence and possible, memory contamination. She's basically, it's these kind of ideas have gotten her a lot of money and a lot of awards. And I don't believe there's any wisdom in any of her ideas. So that's what you worry about with ARCA. You worry about the one juror or the two jurors that will plant their feet in and get convinced by ARCA. And I think I've shared this before. This is also on my channel. Dominic Dunn talking about expert witnesses. I think this is a good time to review that again.
I only cover the trials of the rich, powerful, and famous because it is different for them than for other people, because they've got the bucks to spend on the $1 million lawyers, and they've got the bucks to bring in the expert witnesses. Jurors fall for those expert witnesses every time. I call them whores of the court because they can be bought by either side.
Yeah. So I have a tendency just to take these experts with a grain of salt. It's 11:30 now, or 11:24 now. Aiden Carney is due to face court at noon. Curious to see how much they're going to do on the record and how much they're going to do. It seems like there's going to be a lot more things off the record and done in sidebar. But it seems like Hank Brennan is headed to court to testify in Turtle Boy's hearing. He's got a new judge. That should be interesting. I may stream that here if people are interested. Manny says the king of cold cases dismantled that one expert, Elizabeth Loftus. Can we watch that again? I think Hank will use everything they learned in the same fashion. I'm also lost. They never seem to be a tally. I think Hank will use everything they learned in the same fashion. I'm also lost. Lost how? There never seems to be a tally. Yeah, it never seems to be like there's any real repercussions for lying to the court. I'd love to start Elizabeth Loftus, but I think they're coming back soon, no? Did they say how long this break would be? I missed it. And thank you, Manny. Appreciate it. Appreciate your... Oh, let me reflect. Thank you also for super sticker. Appreciate it.
Court's back in session. May be seated.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
Okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in. your honor's schedule, that would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure. All right. So we'll see everybody back here, not tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will. Thank you, Your Honor.
Okay. So see you Thursday. All right. Thank you, everybody.
All rise to the court, please.
Goodbye.
Bye.
Okay, I'm going to go over to Twitter Boy's hearing, and for those who want to stick around, it seems like you're fun and meet me at that hearing.
I will. I know. I know. I know.
I know that's a terrible fate.
Yes.
That's Thursday.
Thursday here? Here?
Yep.
Here.
Thursday
Oh, are they leaving the day?
Yeah. Probably.
Oh, that's right. They have gag orders. That's all right. Thank you, guys. You guys are awesome. You don't want to get them in trouble, right? Oh, but you know what we can do? I can do one better.
Yeah.
Ted, how do you think today went?
They got a lot done.
Hey, John, I'm up front.
Yeah,
Okay.
they got a lot done. So, I mean, not well, we haven't got the decisions yet, but they got a lot of the.
Yeah.
All right, I'm going to close down the stream, and I'm going to start a new one for Turtle Boy's hearing. See you guys there.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. John, you were my mark. My innocence fraud campaign is my biggest hit yet.